Hello, my name is Jakob Seidler, and I'm an attorney at Husch Blackwell. Today, I wanted to discuss the legal landscape surrounding secretly recording conversations in the workplace. With smartphones and other devices, it's easier than ever for employees or employers to record conversations and telephone calls. But before you hit record, it's important to understand the legal implications of doing so. The first thing you should consider is the laws of the state in which you are situated, as the legality of secretly recording conversations is governed by state, not federal law. States take two distinct approaches when determining the legality of secretly recording conversations or telephone calls. The primary approach, followed in most states, employs a one-party consent rule, which allows recordings as long as one party to the conversation consents. This means that if the person recording is a participant in the conversation, they can legally record without informing the other parties. The second, alternative approach requires all-party consent, meaning that every participant in the conversation must agree to the recording of the conversation. These states prioritize privacy and confidentiality, making it illegal to record such conversations without unanimous consent. Wisconsin is a one-party consent state. Thus, in Wisconsin, secretly recording a conversation does not result in criminal or civil liability if the recorder is a participant in the conversation. The second thing you want to consider is your workplace policies. Although Wisconsin law allows secret recordings, employers may implement no recording policies so long as they are properly crafted. For a workplace to implement a proper no recording policy, the workplace must ensure that the policy does not infringe on the employee's rights under the National Labor Relations Act. Courts have struck down overly broad no recording policies for being too restrictive and potentially deterring employees from engaging in lawful activities. But recent guidance from the NLRB allows reasonable, neutral, no record rules, especially if they serve legitimate business interests, like protecting privacy or proprietary information. Finally, if you're considering using a secretly recorded conversation as the basis for a lawsuit, it's important to understand the admissibility of such evidence. In Wisconsin, in-person conversations that you're a part of can be legally recorded and are generally admissible. However, secretly recorded telephone conversations are treated differently. Under Wisconsin law, the recording of telephone calls is not admissible in civil cases, even if you had the legal right to make the recording. So, if you're thinking of using a phone recording as evidence in a civil lawsuit, it won't be allowed. In summary, both employers and employees should be aware of these rules. Secretly recording conversations is generally legal in Wisconsin, but there are important caveats and exceptions that you should be aware of. If you have questions about recording in your workplace or how to implement a no recording policy, it is always best to consult with legal counsel to ensure you're protected.